Do we have azioni? Per favore. Grazie. Are we ready to rock and roll? All right. There's been a global avalanche of data privacy legislation lately, and it's on everyone's mind. The implementation of the European Union General Data Protection Regulation, or GDPR, sounded alarm bells not only in Europe but around the world. Other countries decided they needed to have their own data privacy regulations, such as Canada, Brazil, the Republic of the Philippines, Japan, and Australia. Now, even states like the great state of California are jumping on the bandwagon with the California Consumer Protection Act. The torrent of legislation has raised a lot of questions, and questions I think are a good way to start. We all played 20 questions as a kid, where one person is the answerer and the other people ask questions, and they try in 20 questions or less to get what the answerer started out with. So I'm going to give you 20 questions in this little clip today that will help you get started on your data privacy preparedness journey. The first question is, what data do you have? You can't manage privacy until you know what data you have. The second question is, who did you get it from and where is it? Merely storing data in a country can trigger that country's data protection law. Even though you may not do business there, your data is there. Question 3, do you have a legal reason for collecting and using the data? In today's world, you need to keep personal data. You must have a reason. You just can't keep it because you want to. Informed consent of the person who the data is about is the best way to do that, but there are other legal justifications as well. The rights of the person whose data it is, that is the data subject, are the core of any data privacy legislation without regard to the jurisdiction. And you will likely have to respond to inquiries from citizens of your own country and perhaps others as to what data you might have about them. Question 4, can you find the data if the data subject asks for it? Will you be able to tell that person how the data is being used? Is the data being used in the way you told the data subject it was going to be used in the first place? These are all things you need to do. Question 5, can you delete that information, that data, if the data subject asks you to? Part of the seemingly fundamental rights is the right to deletion or the right to erasure. You will need to be able to show that you deleted. Question 6, can you prove that you deleted the information? And I'm often asked, do I have to do that by each individual person? No, I don't, in my opinion, think you need to do that, but you need to document that you have a normal business process wherein you remove data that is no longer being used or is no longer being used for the purpose that it was given to you in the first place. Question 7, is the data properly secured? Phraseology varies from one jurisdiction to the other, and adequate and robust have been phrases that have been pointed out. If you have particularly sensitive data, data about children, healthcare data, financial data, data about crimes or potential criminal proceedings, your people who, who handle this data must understand the sensitivity of the data and what their responsibilities are to safeguard it. Question 8, do you perform a data privacy impact assessment every time you start a new software application? This is critical so that you understand if there are privacy implications and required in some cases by the GDPR. Have you assessed what personal information is collected by your cybersecurity technology? This is an often neglected area and comes under the rubric of security. However, security and privacy in this context can be thought of as a pair of magnets that can either attract or repel depending on the circumstances. Number 9, are you holding third parties that you do business with to the same standards of privacy and security that you yourself must adhere to? This is critical. As we saw in the Target breach, it is often the third party that is the weakest link in the chain. You can reflect the obligation of third parties in contract terms and conditions, which is often the way organizations do it. If you are contracting with other people who will have access to personal data, you need to contractually bind them so that they understand they have to do the same kind of security measures that you yourself are required to. Number 10, are you securing the privacy of the personal data of your employees? As Dr. Seuss once said, a person's a person no matter how small. And so an employee is a person too with personal information, and you are under a duty to secure that personal information just as you are under a duty to secure the personal information of a customer. Question 11, do you have trusted external resources such as attorneys or experienced data protection officers that can provide you guidance, references, and sources in situations where you have questions? I really don't care how big your internal organization is, there is no way that you can possibly understand every aspect of every data privacy regulation that you may be subjected to. Question 12, do you yourself have a basic familiarity with the key data protection, data privacy regulations that you are required to conform to? As an example, the GDPR has 2 sections, the first of which is called the recitals. The recitals in the GDPR are very similar to what we in the United States call legislative intent. It is important for anyone in a responsible position in organizations to understand the fundamentals and the philosophy that's conveyed by these documents. Number 13, do you have an adequate and timely breach detection capability? Are the right people notified quickly enough to properly respond? Number 14, do you have a breach notification plan? And under that plan, are you not only required to inform those potentially impacted by the breach, but the data processing authority, the regulator in your jurisdiction? These mechanisms need to be built in. Question 15, do you test your breach incident response and notification plans? Do you document these tests? Do you determine lessons that you've learned from the previous test? And do you document what you need to do as a result of the lessons learned to overall the security of the entire process? Number 16, do you have appropriate law enforcement liaisons in place before you need them? There's no doubt that not every breach will trigger response by law enforcement. The smaller the breach, the less the response. However, you must be able to report the breach not only to insurance and regulators, but to appropriate local and perhaps federal law enforcement authorities. It is in your best interest, in the organization's best interest, to understand these relationships ahead of time. For example, you should understand the difference between reporting to the FBI and reporting to the Department of Homeland Security. When you report information about attacks to the Department of Homeland Security, there are various liability limitations that protect you that are implemented by federal law, and there is no such similar liability protection if you report potential criminal activity to the FBI. 17, are you or a trusted resource, perhaps a subscription, monitoring ongoing legislative activity? By being aware of what legislation is coming down or potentially coming down, you can take preventative measures. So, for example, we know that the California Consumer Protection Act will come into effect January 1st, 2020. It has a 12-month retrospective look, which means you will need to be able to find consumer data for the 12 months beginning January 1st, 2019, this year. And last but not least, have you formed an informal support group of other professionals who are similarly situated and have similar responsibilities to you that you can turn to for advice, guidance, and support, and with whom you can exchange best practices? It is important that organizations recognize they have significant duties to protect personal information of not only customers but employees. It's also important to recognize that the exact definition of personal information varies by jurisdiction. And I'll leave you with one final thought, and that is that it's far easier for employees to assimilate basic core principles than detailed procedures. Thank you for your time.